Professor Lawrence Tribe, a really distinguished legal historian and professor at Harvard University, is the first person I know that said, and he continues to insist, that Thurgood Marshall is was the most important American lawyer of the 20th century. And there are other legal historians who agree with that. Certainly, Marshall had a very dramatic and lasting impact on our nation, particularly the shaping of its constitutional law, and particularly in the areas of racial equality, civil rights, and civil liberties. After law school, he practiced for a few years in Baltimore, Maryland, before going to New York and becoming the chief counsel for the NAACP. And in just those 3 years, he handled several cases that began important changes in our nation's law. And then from 1938 to 1962, he was the chief legal attorney for the National Association for the Advancement of Colored People, the NAACP. And during those years, operating from New York City, he handled cases all over the country, including 31 arguments before the U.S. Supreme Court, 27 of which he won. Of course, his most famous case as attorney was the 1954 Brown versus Board of Education decision that outlawed racial segregation in public schools and began the process of completely unraveling Jim Crow, government-supported racial segregation in a lot of different fields. In addition to Brown, during the period that Marshall worked for the NAACP, he reshaped American constitutional law in housing, in criminal justice, in employment, in transportation, and in voting rights. In fact, Marshall could never decide what was his most important case. He debated with himself and debated with others as to whether it was Brown versus Board of Education, that 54 school desegregation decision, or a case called Smith versus Allwright. That was the case that held unconstitutional the practice in Texas and in most of the South that excluded African Americans from participating in primary elections. The justification that had been in place for many years was that political parties were not instrumentalities of the state. They were private organizations, and therefore the 14th Amendment requirement of equal protection was not applicable to them. But in effect, the exclusion of African Americans throughout the South from the primary election process was really excluding them from effective political participation, because these were states where the primary election was tantamount to election. This is prior to the Republicans having any significant participation throughout the South. Marshall was the chief legal attorney for the NAACP up until 1961. That is when President President John F. Kennedy appointed him to be a federal appellate judge on the Second Circuit Court of Appeals that's primarily based in New York. During his tenure on that court, he had a remarkable record, authoring over 100 majority opinions, and quite extraordinarily, not a single opinion written by Marshall as an appellate judge was ever overturned by the U.S. Supreme Court. Then, in 1966, President Lyndon Johnson appointed him to be the Solicitor General of the United States. That's the federal government's top attorney in court. Argues cases for the government in front of the Supreme Court. And in that capacity, Marshall argued 19 cases before the U.S. Supreme Court and won 14 of those. Then, in 1967, President Lyndon Johnson appointed him to the U.S. Supreme Court. He served on that court for 24 years, and his 24-year tenure remains one of the longest tenures of any justice on the Supreme Court. So I guess you put that corpus of work together, it explains why many people regard him as having been the most important American lawyer, certainly of the 20th century.